In Brazil, many couples build a real life together without formally signing a traditional marriage certificate. Through the concept like union staff, it's so common here. Brazilian law can recognize important rights, duties, and protection for a couple who live together in commitment relationships, often in ways that feel very similar to formal marriage. So, naturally, many Brazilians think if a law already recognizes us almost like America, but then if one of us apply for one kind of residential permanent in US, example EB-5, should US immigration basically see us the same way? And this is exactly where the important strategy issues begin. Because when all of the parties decide to pursue the EB-5 migration investor process, Brazilian domestic recognized and US immigration treaty are not always identical in the practical strategy. This is a difference can directly affect whether your partner may be included smooth as a derivative spouse under your case, or whether poor timing created unnecessary complications. So, before we even discuss a deadline, finding our marriage timing, the first thing is viewers needed to understand is this. EB5 it is not only about investment money. It can also be about relationship time, legal status, and documentation strategy. Let's simplify the foundation first. In general, the EB5 process allows the principal investor their legal response and qualify unmarried child under 21 years old to potentially immigrate together under the principal application case. That sounds simple enough. But here is where timing becomes critical. US immigration is not merely asking, are these two people effectively together? The more strategic question often become, at what point did this relationship legally qualify in way the immigration recognized for derivative spouses proposal? And at what stage of the process did what happen? In other words, you are official married. That's you need to understand. Now, imagine just an example. Imagine John and Anna have lived together in São Paulo, my city, for years, on their Brazilian life and family and even certain legal realities. They may feel fully like husband and wife. John decided to apply Preview 5 as a principal investor. At that time, he filed a I-526E. He is not officially married at that time. Maybe they assume a form of paperwork was unnecessary because in Brazil the relationship already carry a meaningful weight. Here's where the strategies matter. File while single does not always automatically destroy the future spouse option, but is absolutely create a timeline that must be understood carefully and don't make any mistakes. Don't miss the point. Let's make this practical. If you don't file I-526 while single, his cases begin as the principal investor petition. Clear? If during the processes, before filing immigration visa issues through a consular process abroad, or if they are already in US, before adjustment of salary approval, inside US, John legally married Anna There may often still be a path for Anna to be a process as a derivative spouse if everything is handled properly. This is why many investors ask not just can I file now, but also until when does legal marriage time still matter strategically? So think of the processing simplified stage. We explain here in layers, okay? Stage one, I 526 file. Stage two, petition review and approval. Stage three, a consular interview abroad or adjustment of status inside US. Stage four, lawful permanent residency is officially granted. For many genuine couple, the strategic window often exists before that final resident stage. Not necessarily only before I 526E file itself. That distinction is huge. Let's make this even more simple. Suppose that John file the EB-5 in 2026, while official or single. His petition is approved late. Before his final consular immigration visa interview, John and Anna legally married. In many cases, that timing may still allow proper derivative spouse included if managed correctly. But now, let's change one fact. John becomes a lawful permanent resident first. And only afterward decide to marry Anna. They can become a very different immigration strategy. And hard too. At that point, Anna may no longer simple ride the same derivative time path and may stand need a separate immigration process. This is why I understand the difference between before final residence and after final residence is become so important. This video is informational proposed. Always consult a legally US lawyer. My role here as a Brazilian lawyer is just support those that need understand about the path fund, source of fund, manage risks about EB-5 process. Thank you for watching and I'll see you next one. Bye now.